Good evening, everyone. Good evening, Legal Vidya, and good evening, participants present over here. So, just wait for a second. I'm sharing the screen, and from today we will start the civil drafting. And before directly jumping into the civil drafting, as per the schedule provided by the Legal Vidya, today we will discuss about Legal Vidya. Please start after 2 minutes. Okay, okay. I will start after 2 minutes. You just give the introduction. I thought you have already given because of fluctuations. I was unable to. So, okay, okay. Continue, please, Legal Vidya.
Mm. A very good evening to all of you present here. I, Paras Chuk, a member of Legal Vidya. I welcome you all on the 13th class of our 45 days of advanced legal drafting course. So, without further ado, let's warmly welcome our honorable speaker, Ms. Shivani Gupta ma'am, to the virtual stage. Welcome, ma'am.
Thank you, Legal Vidya. And good evening, everyone, once again. So, from today, we will start the new session as per the schedule that is about the civil litigation. Now, from today, we will discuss about all the aspects, all the drafts that are being used in the civil litigation. Okay, so before directly jumping into the drafts, Legal Vidya, as per the schedule, prepared a list of the topics of the definition or concept part. So, in today's session, no drafting is there. I will discuss with you all the major concepts, major definitions that are being provided under the civil procedure code, that is also known as the CPC. CPC is a very student is like just a very difficult thing to the students pursuing LLB or BA LLB. But before that, I would like to share the screen for the same. In the group, I have shared a file, and you can just go through the file because it's not possible for me just to put everything on the screen or in the PPT. So we'll try to move the PPT, but one by one, I will discuss the concepts that are being provided. I think screen is visible. I am just running the same file that is being shared to you all. Yes, Sony, and this is a file. You can go through the file whenever you are free. Now we will start discussing with the as per the schedule. First topic is the hierarchy of the codes. The file contains each and every important topics that are being discussed in the list provided or the index provided. So first of all is the hierarchy of the code. Dear participants, you are all aware of that hierarchy of the code is also being discussed when we started the criminal litigation. So hierarchy of the courts means what are the courts, what's their role, and what's the chronological order just to approach the court. So first of all, when we draw the hierarchy pyramid, I didn't mention anything about the hierarchy of the court because on the very first or second class I have mentioned everything, and today we'll just go through very crisp way. So first of all, it's all the apex court is the Supreme Court, followed by the high courts of the different states. That is followed by the subordinate courts. Now subordinate courts are divided into three types of a court: civil court, criminal court, and the revenue court. Criminal court already we have discussed. Now we will come to the revenue court, not in our syllabus. Now comes the civil court. Civil courts are being followed by the district judge court. District judge court are also followed by the family judges court. Then it is followed by the munsif court. Now munsif court is also munsif court is also there, and this is the only hierarchy. When we discuss about the hierarchy of the civil courts, we have to particularly discuss about the civil courts in the form of a district court or family court or the munsif judge court. So this is the particularly hierarchy. Now comes a very important thing, that is the stages of the litigation. So stages of the civil litigation, or it's just like a stages how to just file the suit, how just the procedure being given. So there are particularly 18 stages are there under the CPC. Dear participants, what I have mentioned upon the screen is the detailed everything, that is detailed everything regarding related to the CPC. Actually, CPC is just like a very how kind of a thing. It's a fear in the mind of a student that how to read those orders, how to read all those sections, how to read all those rules and sub rules and so on. So I have put everything in a very crisp way. Go through once you are done with the session. So there are particularly 18 stages of the suit that we have to follow, and these 18 stages, if you are having the pen and pencil, please just note down, because it's not important just to put these on the slide. That's why I'm not running the screen today, but we'll put something important on the screen itself, because in this I have mentioned the decree also, I have mentioned the plaint also, I have mentioned the caveat definition also, and the whatever the definitions are being required I have mentioned there. Now we'll start with the 18 stages of the civil suit, because civil litigation is all about those stages. First of all, it's start with the presentation of the plaint. First of all, and I will discuss each and every point in a detail very well. Okay, now next is the service of summons on the defendant, followed by the appearance of the parties. Then the fourth step is ex parte decree. Next step is interlocutory proceedings. Next step is filing of written statement by the defendant. Next is the production of documents by the parties. Next is the examination of parties, followed by the discovery and the inspection. 10th step is the admission. 11th step is the framing of issues by the court. 12th step is the summoning and attendance of witnesses. 13th step is the hearing of suits and the examinations of witnesses. 14th step is the argument. 15th step is the judgment. 16th step is the preparation of decree. 17th step is the appeal, review, revision, and 18th step is the execution of the decree. So these are the certain 18 steps that are being followed under the CPC proceedings or the civil litigation. Now we will discuss each and every step in a detail, so you can be acquainted with what are the steps therein. Wait for a second, I'm sharing this file also, so you can be just familiar with the things that what needed to be. Wait for a second, I'm just sharing the file. So but that the CPC file I have shared is very important and hold a relevancy, so please go through that file once, because important concepts in a very crisp manner are mentioned there only. Just a second. Actually, natural fluctuation is there now today. That's why it's just taking time. Wait for a second. I am sharing the file on the screen. We'll share the file on the in the class after the session get over. Okay, if this is okay, then please give a thumbs up. I'm just sharing the screen. Network fluctuation. Wait for a second. I'm just sharing. Please give a thumbs up if the screen is available. Actually, we lost the Wi-Fi connectivity today, na? I think is it visible now? Okay, okay. Okay, thank you. We don't have the PDF for the hierarchy of the civil codes. Smriti Singh, there is no as such hierarchy of the civil code. You have to just gone through the district courts. You have to just gone through the family courts, and there is no as such. And there is one civil court and followed up by the High Court and the Supreme Court. If you need that also, I will share you. Not to worry, Smriti. I think 18 stages of the suits as per the CPC, that is the 1908, is visible to you all. Please give us a thumbs up that the screen is visible. Okay. From here only, I have told you that these are the 18 steps. I'm repeating what are the steps. First is the presentation of the plaint. As soon as you approach the court, you have to present the plaint. Next step is I have numbered each and every step. Number two is the services summons on the defendant, then followed by the appearance of the parties in the court. Next is the ex parte decree, followed by the interlocutory proceedings if something are there. Followed up by then the sixth step is the filing of the written statement by the defendant. Then the production of the documents by the parties, either it can be the plaintiff or it can be the defendant. Next is the examination of the parties, followed by the discovery and inspection, lead to the admission. And there in the as a criminal procedure that we known as the admission, that is known as the confession also in the criminal proceedings. Now framing of the issues by the court, summoning and attendance of the witnesses, that is also being discussed in one step there. Now, oh, wait for a second. Okay, now another step is the argument followed by the summoning. After the summoning, there is a hearing of the suit, examination of the witnesses, cross examination of the witnesses, arguments, judgment, preparation of the decree. If once the decree is being just issued by the court, you can go for the appeal, review, or revision, whatever suits the circumstance. Then that is the after the appeal, review, revision, there is an execution of decree petition that is being followed up, and that is the 18th step, and after that the order is being executed successfully. So these are the 18 steps, and dear participants, you have to just keep in mind all those steps. Once you start practicing in the civil law, you will be just acquainted with, and these steps will be in your mind for always. So there is no need to ki you are doing the rectification, okay, ki learning heart by heart. No need to, just keep in mind and just understand the order. Now there is a detailed discussion also on all the stages we will like to. So if in the entire process, if there is any a person, a student or participant having any doubt, please put in the chat box. Now I will start with the first thing, that is the first step. First step is about all about that the moving to the court and so on. So plaint is provided under the order number. What is the difference between the judgment and the decree? We will come to the judgment and we will come to the decree, then only I will make you available. It's the, I think step number is 15 or the 16, then we'll tell you. Okay, now it's about yes and more. Now it's about first part is first step, that is dealing with the plaint. Plaint is discussed under the order number 7. So always keep in mind where the plaint is given. When you start drafting the things, then the plaint is the first thing that you have to draft. So legal entire machinery is under the civil law is set in the motion by filing a plaint. Filing of the plaint, and plaint is the actual starting point of all the pleadings in the case already mentioned. Plaints have certain particulars, that is the name of the court in which the suit to be filed, same as the civil code, same as the civil code. Next is the name, description, and the places of the residence of the plaintiff. There is a follow-up of certain steps. There is a name, description, and the place of residence of the defendant. As so far it can be ascertained, but we are aware of. Now comes where the plaintiff or the defendant is a minor or unsound person. Then the statement to the effect, and on that behalf, legal representative LR will be there, who will be just doing the litigation. Now next is the facts constituting the cause of action when it arose, the facts showing the court has the jurisdiction, relief which the plaintiff claims against the civil class action. Next is the where the plaintiff has allowed a set of the or relinquishes a portion of his claim, the amount so allowed for the relinquishment. So that amount must be there in the plaint. And not to panic at all. Whatever I am discussing today in the theory will be represented you tomorrow in the form of a draft. So don't be like, I'm just teaching you the theoretical part from the tomorrow. As per the schedule, we will share the uh, discuss the practical aspects and the draft of each and everything that is being discussed today under the 18 steps. Whatever the drafts are possible, we'll try to discuss on the same. Next is the step followed up by the statement of the value of the subject matter of the suit for the purpose of jurisdiction and the court fee. It is an important step actually, and called a court fee calculated by certain methods, and you have to just pay that. After submitting the plaint, court find that it should be submitted before some other court. Then the plaint returned, and this is a very simple thing. Everyone must be acquainted with and intimated that there can be can be given to the plaintiff. Now court also having certain powers that they can reject the plaint, that it does not include the cause of action. Then how the court will take the decision, how court will examine the witnesses, this is the thing. Next is the plaint can be discussed on the behalf of a relief claim that is undervalued or the correct valuation is not there on the plaintiff and he got failed. That's another thing, that the plaint got rejected. Now if the relief is properly valued but insufficient, court stamp duty is paid, court fee, stamp duty is paid, and the plaintiff fails to make such good amount, then also the plaints are being rejected. Suit appears to be a time barred, and the statements in the plaint time barred you will calculate it with the help of a limitation act. Now, when the plaint doesn't disclose any cause of action, so then also the plaint can be rejected. This is a case law also, Ruplal Sati versus Singh, 1982 cases there, where the court held that the whole plaint should be rejected, not the portion of it, because rejection on the portion grant doesn't bar the plaintiff from presenting a flash plaint. So order number 7, rule number 13 of the CPC says so. If once your plaint is rejected on the behalf of non-disclosure of the any cause of action, then you can file the fresh petition with all the improvements or the changes required. Next is the servicing of the summons. Servicing of the summon is particularly kind of an instrument that is used by the court to commence a civil proceedings and is a means to acquire jurisdiction over the parties. This is a process directed to the proper officer, requiring him to notify the person named that an action has been commenced against him in the court from where process is issued, and the person is required to appear on a day named and the answer the claim in which such action. Now, when the suit is duly instituted, summons may be issued to the defendant to appear and answer the claim. Another part is that the defendant to whom a summons has been issued may appear in person or by the pleader duly instructed by a pleader complaint, accompanied by some persons who is able to answer all the questions. To expedite the filing of the reply and adjudicating of the claim, the court may direct filing of the written statement on the date of appearance and issue suitable summons for that purpose. Failure to do so may result in ex parte judgment under the Order 8, Rule 10. Provisions of the substituted services to have to be resorted when the summons is not served by the normal process through the court bailiff. Now the thing is that when the court is satisfied that there is a reason to believe that the defendant is keeping out of the way for the purpose of avoiding services, or that any other reason that the summon can't be served in the ordinary way, the court shall order summon to be fixed up by a fixing copy thereof in the conspicuous part of the house. And this is given under the CPC order number 5, rule number 20. Order number 5, rule number 20, you can refer afterwards in the through the Bear Act. Now, expedite services of the summon, one more than one provision is related to substituted any of the services under which the court services by an advertisement in the newspaper. Then that is also being given under the order number 20, rule number 1A. Now, next thing is appearance of the parties. Then appearance of the parties upon the servicing of the summon, the servicing of the summon, the parties shall attend the court unless the court hearing is adjourned on a fixed particular date. And those such dismissal doesn't bar any kind of a suit. Next is the ex parte decree. Ex parte decree means a decree that is against the defendant without hearing, or particularly ex parte decree in the courts are being passed when there is an absence of the defense, and absence of the defense is recalled 2 to 3 times. If there is a continuous absence of the defense, then only the court is just like passing the issuing the ex parte decree. Now, ex parte decree is given under the order number 8, rule number 10 of the CPC 1908. Next, the step is followed by the defendant doesn't file any pleading. It can be lawful for the court to pronounce judgment. These are the points you have to just go through once. These are not the things to keep in mind always. Whether the plaintiff appears and the defendant doesn't appear when the suit is called up for the hearing and summons is properly served, the court may take an order that the civil suit will be heard, and this is given under the order number 9, rule number 6, clause 1, subclause A. Now, X party decree is passed and the defendant satisfied that he has prevented by sufficient cause, then he has following remedies. Remedies is that he can apply for the review. Remedies is just like he can apply for setting aside. He can remedies. He can prefer appeal for the same. And one case were there, UK versus Younger Consultancy Services case were there. It was observed by the court that the word sufficient cause has not been defined and it will depend upon the facts and circumstances of each case. And the sufficient cause bit can be different from one case to another. Another step, that is the fifth step. Now comes the fifth step, deals with the interlocutory proceedings. Interlocutory proceedings are between, that is the period that is being involved between the initiation and disposal of the litigation. So when there is an intervention of the court due to maintaining the position that is prevailed on the date of litigation, or there is something like it's not finally determined the cause of action but decides some intervening matters pertaining to the cause. For example, temporary injunctions as per order number 39, arrest attachment order number 38, receiver appointment order number 40, commissioner appointment order number 26, written statement WS order number 8. So these are the some of the facts on which the interlocutory orders or interlocutory proceedings are being communicated or are being executed. Now comes there were certain amendments being made in the CPC also. Now comes the production of the documents. Once the written statement by the defendant is filed, then the next stage of the suit is to documents on the behalf on this particularly stage. Both the parties have to file the documents in the court which are in the possession or power. If the party rely on some documents which are not in the possession, that in case have to apply to the court for the issue of summons to authority, or the persons who possess these documents are have to deposit in court cost of such production document. So this is the like a bhatta or a thing that if you are getting any of the document, you have to just pay some amount in the court. Followed by the examination of the parties. Examination of the parties is like important stage. It's like the before the parties are didn't appear before. So it's like a first hearing of the suit. The courts ascertain from each party that is clear that whether he admits or denies such allegations that are being made under the written statement or under the plain. Admission and denials shall be recorded. Examination will be done, and examination will be oral examination, and this is done as per the order number 10 of CPC. Now the another step is the discovery and the inspection. Discovery and inspection is given under the order number 11. Admission is given under order number 12. Important is admission. Admission is just like when the party may be called upon the other party to admit within the 7 days from the date of service of the notice any document, saving all just exception in the case of a refusal or the neglect to the admit after such notice. The cost of proving such document shall be paid by the party. So neglecting or refusing, whatever the result may be, unless the court directs, and no cost of the proving any such document shall be allowed. Next is the order number 14, followed up by the framing of issues. Framing issues is like a job of framing of issues except exclusively designed assigned to the judge of the said district court or said or civil court. The job is and the issues are framed under the provisions of order number 14, rule 1 of CPC. Now there is another concept we have discussed, that is the rule number 1. Sub rule number 1 states that issues arises when a material proposition or a fact of law is affirmed by party and denied by the another. Next is the sub rule 2, sub rule 3. You need no need to prepare. Actually, important is the summoning and the attendance that of the witnesses, that is given under the order number 16. Another thing is the hearing of the suits and examination of the witnesses, given under order number 18. Next is the argument. Argument is just like as soon as both the evidence is over. Those, so now the suit is kept for the argument. Evidences has been submitted. Cross examinations are being done by the plaintiff and the defendant. Both sides are allowed to present a summary of their case and evidence to the judge in the final argument. Now comes a very important aspect, that is the judgment. Judgment means what? Judgment in the daily language we discuss about the judgment a lot. Judgment is given under the order number 20. Judgment means any of the statement that is being given by the judge on the ground of which the decree is passed. Now comes to the mind that what is the decree. Decree is particularly is just like contains a number of name, number, details, description, and it's just like particularly the relief what is being granted. Now if the any kind of a relief is being granted, then what happened, the court has heard all the has been heard that shall pronounce the judgment in the open court within the month of the completion. And judgment is moreover like or the court, the according to the court, the case has been litigation has been disposed in the following way. Decree and decree preparation of the decree. Preparation of decree is given under the order number 20, rule number 6A. Judgment is delivered by the decree is prepared by the concerned clerk. The decree shall agree with the judgment. It shall contain number of suit details, or something like names, description of the registered parties, and so on. Or what are the reliefs, specifically, clearly the reliefs that are being granted, or the determination of the suit. Now comes the appeal, review, revision, same as whatever we have discussed in the civil law also. Now, regarding the appeal provisions, there is a time limit for the High Court, 90 days, and for the District Courts is 30 days. And if the limitation period is expired, then would will happen. Then the application for the combination of delay is also required to be moved. And after that, if the court may thinks fit, so okay, that the suit must be maintained or the appeal must be maintained, then only the appeal is maintained. Another is a review. Review doesn't have as such very wide scope, but it has very limited scope. Just like in a very few of the cases, one out of the 1,000 cases, the review is being done. There are certain conditions where the review application is being maintained, and those conditions including the party was aggrieved on the behalf of the disclosure new important matter of evidences, okay, which after the exercise of due diligence was not within the knowledge or could not be produced by him. It's an order degree or the order from which no appeal is allowed. And now comes the revision. Revision, a high court have the jurisdiction for the revision, and they can also interfere in any of the cases that is being decided by the lower courts. Now comes the another step, last step, that is the of the decree. Execution of decree is given under the order number 21. Article I'm remembering here of the Constitution. Execution is which a medium by which a degree holder compels the judgment debtor to carry out all the mandates of the decree, all the claims that are being made, or the orders of the case. It enables the decree holder to recover the fruits of the judgment. The execution is complete with the judgment creditor, and the decree holder gets money for one thing awarded to him by the judgment or the decree or the order. This is the basic thing that is being provided as per the 18 steps of the civil litigation. I will start taking one by one queries. So please put your queries in the chat box, because I can understand there are lots more queries today because it's a very new aspect. 18 steps that I have. Madam, what is the difference between the judgment and the decree? Okay, Anmol, as I have stated, Smriti Singh, ma'am, instead of dictating, can you explain these steps? Actually, when we will prepare the draft of these steps, then only you will be able to understand. First and foremost reason is to just dictate today's session is because I have to just make you acquainted with the terminology. I have to just make you acquainted with, okay, these are the steps and we will follow these steps in this chronological order. So there is no relevancy to explain these like this. And the second thing is, when we will start doing the drafting, either we start to do the drafting with the plaint, then I will explain what the plaint is, what are the ingredients, or as I already told you what's the ingredients. And most important thing, many of you requested only to put everything on the screen. That's why now what I have to do, if I put one word, then also students have the problem that ma'am, please put more of the law. If I didn't put anything, but because the matter is just like, either I can put on the screen or I don't put on the screen. So it's not about dictating. And then another point is this, that when we will discuss about the framing of the issues, then I will let you know that, okay, these are the aspects, these are the ingredients, this is the process being followed during the framing of the issues, during the appeal application, review application, and so on. And what is the difference between the Smriti, I hope you understand this, because if I just mention admission, then you will be like, you must mention the law regarding the admission. So there is no less option left for me just to dictate rather than anything. Next is judgment and the decree. Under the decree, the claims or the reliefs are being provided, and judgment is just like pronouncing in the court, where the the person, the aggrieved party can claim for the same. Next is किसने पूछा है question? Ma'am, can you explain what is the order and its purpose? Order regarding what? Order is just we are just coding the law, na. So if one comes to code the law, either we code it in the form of a section, subsections, either we code in the form of articles, clauses, subclauses, and rules. And the same way in the civil procedure code, the law is coded in the form of orders. And the main purpose, as there is no as such purpose being mentioned in the commentary also, but the main purpose after studying the order is just CPC civil litigation is very vast, so we have to just put everything in a single window. So for one single window we have used the word order, and just to codify the law. Anamika Sharma, what is the difference between order, judgment, and the dusty order? Look, Anamika, when you visit the court, the district court or a civil court in your jurisdiction, then there are certain terminology that are being not used properly. Dusty order, I didn't get you because it's a Hindi word, but judgment is a thing. Judgment is just like a order that is being passed, announced, pronounced by the court on the behalf of the plaint or the claims, and after the examination, cross examination, and the arguments of the parties. And the dusty order, I didn't get you. And order, there is no as such thing like a order. Either the decree is being issued or the judgment is being passed. Yes, anyone else have any questions? Do please ask. From tomorrow we will start the drafting. Then only we will just make you. I can make you acquainted with. Okay, these are the ingredients. These are the things. But for the today's session, you have to just keep in mind about okay, all these the steps are there, and we have to follow these steps for the civil litigation. If you can hear me and I am just giving the answers to your query, either put a thumbs up or say yes or no, ma'am. It's a monologue kind of a session. Madam, I have heard this multiple times that we have to get a copy of Dasti. Bache Anamika, it can be a local terminology, or in the Hindi belt the term will be used. Yes, your question is absolutely fine. I'm not saying why you asked me this question, because in the local courts, even in the local cities, tier 2, tier 3 cities, there are certain terms used in the Arabic also. But in the Dasti, I didn't heard the word. Na, that's why will try to just clear a doubt, or till Monday, I will ask any of the senior, my professor, that what's the term dusty in the CPC says so. Because there are certain terms that are being used in the Urdu language or any other language, local language. Yes, I will, Anamika. Yes, anyone else have any query or questions, then please ask or put in the chat box. And dusty for till where I am understanding, it's a copy of a decree only. Dusty must be like that. Maybe Hamsad. Madhukar didn't get you. It can be Dusty someone in the order 5 or rule 9A. Thomas Dusty. Actually, during the civil litigation and criminal litigation, both, actually, we are just studying what is being mentioned in the Bureau of the English language. There are certain language on the terms that are being used, and that are we are not studying as per the Bureau provision. So that can be that also. Not to worry for the Dusty, I will make you available. What's the term is? Yes, anyone else have any questions, then please do ask. Or either just once go through this PDF also. I will share you this PDF after the session. 18 stages of the civil procedure suit under the CPC 1908. Yes, Anamika. Anyone having any doubt, please ask. Everyone got the point. Everyone got these 18 stages. Presentation, summon service, a party appearance. Okay, Sony. You didn't miss the Supradari. Now, as per the BNSS is enforceable, Supradari is just now removed. That's why I didn't discuss in the criminal drafting. No as such relevancy of the same now, Sony. Akash, you have asked, are all the points considered by the all the plates considered by the court? Yes, Akash. For the yes, Anmol, I will share. Yes, Anamika, I will explain. Actually, that all the plates are being considered by the court, but there is a clause for the rejection of the plates also. Look, one thing. First and foremost thing for the rejection of the plate, it just like your plate is not complete. Your plate is not as per the law, your plaint is not the as per the order number 7. Incomplete plaint without the relief claiming plaint, without the description of the parties or any kind of a incompletion in the plaint will be lead to the rejection only. Else the plaints that are being that are being filed or the suit instituted in the court are just for claiming the relief. So there is no as such particular reason, but incomplete plaint not as per as rule of order number 7 are being rejected. I will share this in group. Yes, point number 2 in the short once again. Servicing of the no investigation. Investigation is done under the criminal law, Akash. Here, there is no such investigation. Is there? Here is an examination, cross examination of the parties, and the arguments are there on the same. It's a civil kind of a nature of a suit, na? Investigation is required in the criminal cases where you have to collect the evidences like forensic evidences. You have to collect everything, panchnama evidences, and so on. Investigation is conducted under the criminal law only. Yes. Anyone else have any question? What are the penalties for the breach of civil decree judgment? There is no such penalty. I had didn't heard this done. Actually, once the decree is being issued, the judgment is being passed, then you can file the execution petition. What is Panchnama, Anmol? Array, Panchnama is in the criminal law, Anmol. It's not here. Panchanama is if the any of the investigating officer recover any of the weapon, then the in the presence of any of the witnesses, then the weapon will be sealed and the signed by the cross signed by the witnesses available there. That is the Panchanama report being prepared by the investigating officer in the criminal drafting. There is no as such penalties for the breach of a civil decree judgment. There is thing like you can file the execution petition. Yes, if anyone have any query, then please let me know as we wrap the session. Madam, point number 2, Anamika Sharma. Point number 2 is servicing of the someone on the defendant. Once you file the suit in the court, now what would happen? How the defendant will come to know, okay, this is the thing that you have filed in the court. The court will summon that the defendant will file the WS. So defendant could put the service of the WS written statement in the answer to the plaint or the allegations being made, either the acceptance or the denial. The summons are being sent. Summons means the information or the legal notice kind of a thing sent to the defendant. Yes, okay, Anamika. Thank you, Anamika. Yes, anyone have any query? Okay, Prableen. I think we should wrap the session and tomorrow we will take the class with the civil drafting. Happy learning. We'll share you the PDF in the group itself. Stay safe, stay healthy, take care. अपनी हेल्थ का ध्यान रखो सब लोग. हेल्थ इज वेल्थ. और बहुत अच्छे से पढ़ाई करो. लॉ इज ऑल अबाउट रीडिंग 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 प्रैक्टिस एंड प्रैक्टिस. लॉ इज ऑल अबाउट रीडिंग. जितना हो सके उतना ज्यादा रीड करो. रीड एज मच एज यू पॉसिबल. Read it, just develop the habit of reading, then only you can successful in law. And reading is a daily process, like you are having a lunch, dinner, breakfast daily, you are having a walk daily, class daily. In the same way, you must read daily, and this is the only thing to just get rid of the law and excel in law. And one more thing, yes, I forgot in the starting of the session. No one has shared. Only I think one or two students have shared me the difference between the RIT and the SLP. Share me the difference. I will check that. Okay, how much you can get the concept. Okay. I think we must step the sessions. Any good book for drafting of the civil and the criminal? Ranvijay, I am so sorry to tell you, there is no such particular good book for the drafting of the civil and criminal. Drafting is a kind of kind of a crafting thing. But wait, I have a single book also, one single book also. I will share you in the group with the photographs of the book. If you wish to, then you can purchase it from the Amazon. But no specific book. Some students are saying that the law fighter books are best. Some are saying that the drafts that are being available on different law firms website is good. For the reference, I'm sharing you most of the drafts. Either refer to them only. If you else you need the book for the reference, you can refer the book of the single also for the drafting. And one book or is another book is also there. I will share you the photograph. I have the book in the shelf. Will share you reference book for CPC. Any good author? Yes, the Takwani is the best. Go for the Takwani. Even I have the old version and the new edition of the PC Moga book is there for the Moga book is there for the drafting especially. Rahul for CPC go for the Takwani. And Takwani is the best. You can't skip because there are certain other authors also writing the CPC. But if you want to excel in CPC, please don't skip Takwani. The best book. When you start studying Takwani, you will be like, what is this? What is that? How I would cover? But best book. But Moga book is also there. Ranvijay for the black one. I have the black one PC Moga book picture of the text man. Rahul Takwani book picture. I will share you the index of the Takwani. I myself is to prepare from the Takwani only and recommend the students also for the same. Yes. Okay. Arey, if you need a CPC notes, CPC notes I have. CP notes I can share you because I didn't prepare the BNSS notes because BNSS is enforced recently. Na? I prepared the CRPC notes also in the detail for the student. If anyone needs CPC notes, I can share to them. And rather than that, if any other subject for criminal, madam, for criminal, if you are studying the old laws, then Ratan Lal, Dheeraj Lal is the best to go with. Or in the Kelkar is there for the CPC. CRPC Kelkar CRPC. And for the BNSS, look for the BNS. I myself didn't purchase any textbook. I'm just referring the BRX and the material of the different law firms. So Madhukar, sorry for the new criminal laws, but go for the BRX first. And these EBC BRX are the best to go with. Tabular tables are given, comparative tables are given. Yes. If anyone need any help in the any other law subject rather than the drafting, please feel free to ping me. Would ever like to help you in any manner I can. I would like to. If you need any help in your academics, in your periodicals, or in your project assignments, dissertation, and so on, please. Yes, for the jurisprudence. Okay, jurisprudence is one of my favorite. For the jurisprudence, now you do one thing. One thing is this that there is a book named Anirudh Prasad. Anirudh Prasad book jurisprudence. It's a book is in Hindi especially, and this that book is a very pure kind of a book. One must read in their life once. The jurisprudence Anirudh Prasad. And for the academics, you must refer Pranjape. Namita Agrawal is there. Pranjape is there. So go for both. Okay, IPR. Acha, dear students, I will do one thing na. I will mention the list with the authors, list of the book with the author's name, and will put in the WhatsApp tomorrow. Yes, at this I will do tomorrow because I think every student is deprived of these things. I can understand your pain. Yes, I will. I will. For the interpretation, two books are there. Mathur book is there for the interpretation of statutes. DN Mathur book is there for the interpretation, the best book. And one another book I am referring to, that's an old book of my time when I was pursuing LLB. So I will share that pic. And for the interpretation is done IPR. Okay, for the IPR, just keep your eyes closed. Just go for the BRX and more. First of all, go for the universal BRX. Then for IPR, VK Ahuja is there. It's a blue cover book, not even been updated till now. I have the 21 edition till date in the library also. So I for IPR, go for the VK Ahuja. IPR is a very interesting subject, and if you need any help in IPR, always there to ping, always there. And yes, please, any other subject what is taught in the ADR subject? My college actually is Sony. I think no college is conducting the ADR. ADR is a practical subject where you have to just discuss about five things. First things it's an alternate dispute resolution. So it's a mediation conciliation is there, and you have to just study about that only, and then you have to follow it up by the lok adalat. Sometimes the universities have the syllabus of the lok adalat also. Okay, now arbitration, mediation, and conciliation is there, and you have to prepare a practical file of it depends that how your college is asking you to prepare. In our college the file is prepared upon the legal page. If you need the ADR file or theory, then I can share you the material. So I have a loads of material. My laptop is full of the law material only. If anyone need any material, na, just ping me on the WhatsApp. Will share you when I will get the time, na. And I just like to help the students. ADR classes are not such conducted either in the when your periodicals will be over, when they, just before the practical sessions, 2-3 classes will be conducted, and you will be acquainted with arbitration, mediation, conciliation. So it's not a big deal to crack for the ADR. And in the ADR, you have to discuss about the NALSA also, and DALSA also, and the Lok Adalat. Yes, anyone have any other? Yes, Sony. Yes, anyone have any other doubt, query? Just put in the chat box. I hope your doubts are clear. I will put the book list in the group. I will definitely put the book list in the group tomorrow. Yeah, I will tomorrow. Yes, Ranvijay. Then that might be helpful for the students. Yes, please, and just develop one hobby, dear students. You are pursuing the law. Please just develop the hobby of reading. Just that must be like that. Okay, you have not done your dinner, so you are not able to sleep. That's why. And the another thing is that you have not read. That's why you are not able to sleep. So just make reading your hobby, make reading your lifestyle. Then look how you excel in the law, because no one asks the law student just to develop the hobby of reading, and I am also the victim of the same. So that's why now I am just suggesting each and every person who is pursuing law, who is in the law, who is doing law, who wish to pursue law, just please develop the habit of reading. Because once you have developed the habit of reading, then if there is something just last minute being updated, you will be in the position, your mind will be like, okay, we just get it. And so, and then for the litigation especially, you have to go through the commentaries and so on. I hope the session is interactive today. You enjoyed, because I think session was going boring, monologue kind of. I think there must be such like discussions also. Yes. Okay. I think we must say good night now. If there is any query, then please put here, or else just a WhatsApp away. A book list I will post. And thank
Thank
you, everyone. Yeah. Yes, please.
Thank you, ma'am.
Yes, legal.
As we come
Fine.
to the end of our the 13th session on the advanced legal drafting course, then thank you, ma'am, to introduce about our the civil drafting, and we have ended about the criminal drafting. And if anybody have any query, they can ask. Also, every participant have to share their task with me, and the task have the numbers. Without that certificate, will be creating after the completion of course. So everyone have to complete their assignments on time. So you have to complete your assignments by end of this week and send it to me. So kindly note out that. Thank you so much who have joined, and looking forward for the upcoming sessions. And kindly send your assignments to me by the end of the Sunday, by the end of this week. Thank you very much. Good night. Happy learning.
हैप्पी लर्निंग, स्टे सेफ, स्टे हेल्दी, अपनी सेहत का ध्यान रखो, खूब पढ़ाई करो. हैप्पी लर्निंग, गुड नाइट.